I mean, that's it was so stupid.
All right, welcome everybody. It's nice to see everybody for the first in a series of talks today. Those of you who were able to be here in November, you'll know that this is the first year we've had a Center for Race, Immigration, Citizenship, and Equality at UC Law SF. It was also the first year we had it at UC Hastings last November. So I'm very excited to be able to launch this center with this colloquium really being the centerpiece of what Rice is doing in its first year. And I think also a really good representation of the mission of the center as I see it in the years going forward. So the center, Rice, is meant to help advanced conversations about race, immigration, citizenship, and equality, which I think are too often separate conversations, particularly in law schools. A lot of times conversations about race focus on domestic race relations. And a lot of times conversations about immigrants focus on Asian and Latinx individuals. And I think Anna Law, who we brought here as our inaugural speaker for this series, her paper was a great example of why we created Rice, and it's why I asked her to be the first speaker in our series, because as you will know, having looked at her paper today, it crosses a lot of boundaries. Right? It is very much about Black-white relationships during the Civil War, antebellum, and then Reconstruction period. But it is very much interwoven with a story about migration, both within the United States and from abroad, particularly with Chinese workers who come into the picture as well. So the mission of the organization, again, is to keep having these kinds of conversations. A couple preliminaries before I introduce our speakers and our topic today. This is the first of 6 speakers who will be coming this semester. Beginning today, they'll be every other week on Thursdays here in Deb. There's one exception, which is Dean Chemerinsky, who may be in a different room. We're currently scheduled him to be in a slightly larger room because there are 4 sections of con law who might be really interested in coming, in addition to what I hope will be a steadfast group, although you're free to come whenever you want, but I'm hoping there might be a steadfast group for this series. So every other week on Thursdays, there'll be a talk on 12:30 with a different speaker who's coming from a different university. That speaker will always be in conversation with one of our own UC Law faculty. So that will be a fun part of our conversation. And we'll always also try to incorporate questions from the audience that's here in the room and the audience that's online. Today we have 2 discussants, so there might be a little bit less time for discussions, but I'll say a little bit more about why that felt like a trade-off that was well worth it for our first week. So I don't see a lot of food. I just want to mention that you are welcome to bring food and for this to be a brown bag lunch. For those of you who are not students, you are also welcome to donate money to the center so that it doesn't have to be a brown bag lunch instead. So I'm probably saying that more to the working people who are online. Our format today, sorry, let me introduce our speakers first, and then I'll turn to the format. We have as our guest speaker, Professor Anna Law, who holds the Herbert Kurz Chair in Constitutional Rights at CUNY Brooklyn. She is a political scientist by training, historian by methodology, and by subject area expertise is a scholar of constitutional law, immigration, citizenship, and in particular, the antebellum era. Her first book, The Immigration Battle in American Courts, was published by Cambridge Press, and it examined the role of the federal judiciary in US immigration policy, and also led to an institutional study of the Supreme Court and the US Court of Appeals and some of the disparities in the results among immigration courts. It's a project that I know Professor Law has been working on with Professor Masalo and some of the other CGRS folks who are here on our campus. Her current book, from which the chapter you have is drawn, is under contract with Oxford Press. I understand you're still deciding on the title. It has the word immigration, federalism, and slavery in it somewhere.
I don't want to put federalism in it because people's eyes are going to glaze over.
Not for law students.
Not for law students.
It might mean that it's a bar subject if you put federalism. The chapter you have is part of a work in progress, which is also, I hope, a hallmark of this series, is being able to learn about work that is in progress, often at the cutting edge, the vanguard of different fields of scholarship, but also an opportunity on both sides to be able to have a genuine conversation about how the ideas can fit into ideas that are still developing in scholarship, in society, and elsewhere. You know, a lot of times when you hear things that are published, it's baked, it's done, the speaker says thanks, and there's nothing they can do about it for that paper. So that is the upside of having these draft papers. So after Professor Law presents her paper, we'll have two discussants. First, we have Professor Jack Chin, who is a law professor at UC Davis. He is a teacher and scholar of immigration law, criminal procedure, and race in the law at UC Davis. His efforts with students to repeal Jim Crow laws that were still on the books included a successful 2003 petition to the Ohio legislature to ratify the 14th Amendment, 136 years after state disapproval of it during the ratification process. He's worked with students on many other projects. I will add, and he recently authored a paper on Dred Scott and Asian Americans, which is why I asked him to come today, because I know that he and Professor Law will have a lot of interesting ideas to exchange with each other. And I'll just add that I really appreciated that in Professor Chin's official bio, he talks so much about the projects he does with students. And I will say that he may or may not know this, but he's one of the reasons that I went into this profession. Because when I was a graduate student, I met him at a conference, having read his work, which is some of the seminal work in Asian American jurisprudence. And I think his first question to me was, I'm working on an edited volume. Do you think you want to publish something in it? So, I mean, I think that spirit of treating students as colleagues and equals is something that I've always appreciated, and that I think will be, will help lead to a good discussion today. After Professor Chin, we also have Professor Richard Boswell, who's here on the faculty at UC Law SF. Professor Boswell's written extensively in the field of immigration law and is the author of more than 11 books and 17 articles. I'm sure it's probably higher than that now. I think your bio probably needs a little updating. His most major books include Immigration Law and Procedure, Cases and Materials, Refugee Law and Policy, a Comparative and International Approach, which is co-authored with Professor Masalo. He's testified on numerous occasions before congressional committees and is a frequent lecturer on immigration law nationally and internationally. His article is one of the seminal articles on race and immigration. It's a piece from, it's a couple years old now, it's in the 1990s, maybe? No, it was a post 9/11 reflection, but it was early 2000s. Professor Boswell wrote a piece on race and immigration, which is part of why I thought of him as a great discussant for Professor Law. So let me turn the podium over to Professor Law. She'll present her paper, then we'll turn to our discussants for about 15 minutes. And then with the time remaining, we will take questions from the audience. If you are online, I'm going to encourage you to submit questions using the Q&A function. I'll still see it on chat if you forget, but the Q&A function is a little more open. So with that, Professor Law, thank you.
All right. Everyone, and so I'm the inaugural speaker, which is no pressure at all. I mean, Professor Chen hasn't even seen me present. I could be awful. So I guess she likes suspense. So now the advancing thing is not working. The clicker thing is not working. Oh, there it is. Okay. So here's what I thought we would do today. I would start with a research question of what's the question I'm trying to answer in the book, and look at what are the state level restrictions on freedom of movement and freedom of remain. So the 19th century, before the federalization of immigration policy, we find that it's not just a matter of the freedom of movement. It's not a matter of can you go where you want to go into the country, across the country. It's can you stay in one place, a place of your choosing, without being harassed by de jure laws. I'm not even talking about private vigilantism and mob violence. I'm talking about laws on the books. can you have the freedom of movement and remain? So a short agenda, but let's see. Either my battery is dying or it won't. Okay, I need the next slide. It's not really going.
Where's Mikey?
It's this one, right?
Oh.
Okay, I'll just use it manually. So here's the research question I'm trying to answer. We are in a federal system in the United States, and where's the dividing line between the authority of the national and subnational governments on the question of migration? And you're thinking, lady, why are you taking 11 years to answer that question? Because before the Civil War and the Reconstruction amendments, man, it's a pain in the ass. Okay, so we now understand immigration and migration and citizenship as to be managed by the federal government. That wasn't always the case. Okay, so here's some characteristics of migration policy before the Civil War. The states and the localities ran migration and citizenship policy. And the states, what do I mean the states ran migration policy? I mean the states, like the state of Massachusetts was deporting people to Europe and to other states and to Canada. The state was deporting people. The body was called the Board of Charities in Massachusetts in the 19th century, which was none too charitable because they were deporting people. And what other aspects of antebellum migration are there? We find that international and domestic migration, so the same body, the same states and localities that control international migration also control domestic migration across the country. We also see that the fates of indigenous people, free and enslaved Black people, and European migrants are all relational. So let me give you a quick example. In the 1830s, as the cotton gin was invented and the explosion of cotton prices, the white enslaving people in Georgia and Alabama greedily eyed the land owned by the Cherokee and other native people because they wanted that land to grow cotton and to expand slavery, because for them it was money. And so in the 1830s, there culminates a point where the federal government uses all its power to forcibly and violently deport 80,000 Native people to make way for the expansion of cotton and to make way for white families moving out west. So the ability to stay in one place and to move is relational during this time period before the Civil War. Because of the time period, because my book starts in the colonial period, I also ran into slavery left and right. And I've come to the realization that I cannot tell the story of US immigration history without also talking about slavery. I'm not arguing that slavery is the same as migration, but slavery is an institution that brings 300,000 people here to the colonies and then to the states. And then through natural reproduction, by the time of the Civil War, we're up to 1.2 million. If it were for slavery, where did these people come from? We have to address slavery also, because I'm finding in each time period, the existence of slavery also affects policies on voluntary migrants. And I'm also, and the biggest effect of slavery, the existence of slavery, is that it delays the federalization of immigration policy until 1882. That's over 100 years. So the next few slides, I want to show you that, so you're saying, I said that the states were running immigration policy. What did that look like? What we understand as migration policy today, run by the Department of Homeland Security, Border Patrol, TSA, that conception, migration policies take very different forms in the 19th century and before federalization. It's not Border Patrol, it also takes on regional variation. So whatever we understand of what migration policy looks like today, get that out of your mind, and I will show you some examples of what it looked like back then. Okay, so let's, you guys are lawyers. Let's start with the Constitution. Yeah, I read the Constitution about where's the dividing line between the national government and the states on migration. Totally useless, I gotta say. All right, so here's a parts of the Constitution that are supposed to help me answer the question. Yeah, the Commerce Clause, which is supposed to nationalize everything, the economy, fiscal policy. It would seem that the feds should have taken over immigration a long time ago. Nope. Why? Because we have a federal system, right? Created by Article 1, Section 8 and the 10th Amendment together creates a US federal system. And from that federal system grows a body of law under police powers. Police powers, anything having to do with health, safety, morals is left to the states and the localities. Now, all of a sudden, you're seeing in your head, this is how all the states retain control and justified control over migration constitutionally. Okay, what about privileges and immunities? That should cover people coming and going and the freedom of movement. Okay, but that covers the privileges and immunities of citizens. This study is looking at people coming from overseas, so they are not citizens. And then we have domestic people who are, enslaved people and are human property. Not great at all, but at least that's clear. They don't have no citizenship. What is the citizenship status before the 14th Amendment birthright citizenship clause of free Black people? It's not clear. And so you're going to see why it was constitutionally allowable for states to have laws restricting the movement, the internal movement of free Black people. Okay. So I'm going to go over this slide, next two slides very quickly in the interest of time. The restrictions take on regional flavor. The Northeastern States, they are most afraid of poor people, sick people, disabled people, people with communicable diseases, people who cannot support themselves, people who are going to bring diseases into the country, health, safety, morals. And so that's the group of people. Remember, there's no welfare state policies, no unemployment, disability insurance, Medicare, Medicaid, Social Security, none of that. So under Elizabethan poor laws, which got transported from the colonial period to here, the poor people, disabled people who can't take care of themselves become the social and financial responsibility of the place where they are legally settled. So states don't want poor people, disabled people from abroad. They don't want poor people and disabled people and sick people from other states where they are not legally settled. So the Northeastern states, that's who they are most afraid of. The Southern states have a different set of concerns. Every slave state on the eastern coast, they didn't want free Black people. There were free Black people that worked as sailors. And so these huge, large numbers of Negro seamen laws, they were called, that restricted international Black sailors who worked on ships, these are free Black people, that worked on ships from England and from France And they also didn't want free Black people coming on ships who worked on those ships from Boston and Connecticut. Because from the slave states' point of view, they called them moral contagions. We cannot have free Black people wandering the town of Charleston, intermixing with the enslaved people, giving them ideas that free Black people, it's a thing, that Black people can earn their own living. So they said, the Southern states said, just as the Northeastern states can ban people because they might have communicable diseases, we under police powers can ban people because they're moral contagions. And they're going to start riots and insurrections with the slave population. So in the Western states, what's happening? And this is what the paper is mainly about, this chapter, which I thank the discussants because it is very drafty. And it's gonna undergo many, probably 20 more revisions before it comes out in print. So the Western states, they have a different problem from the other regions of the country. The Western states, they don't want the Chinese. The Chinese are coming in large numbers by the 1850s. The Western states, including California, they don't want free Black people either. The vision was among political elites, the Western territories and the new states are for white families. We don't want free Black people. We don't want the economic competition and of all these Chinese people. So there's all sorts of attempts in the Western states, including California, to ban the Chinese, to saddle Black and Chinese people with legal disabilities, which they succeeded in doing, anti-mezination laws that you can't marry white people, that you cannot, Chinese people and free Black people cannot testify in court against a white person, thereby leaving them sitting ducks for crime. And they cannot attend their children cannot attend public schools, cannot serve on juries, all these sorts of restrictions. These states were hoping to make it so bad that that Chinese people and Black people wouldn't go there. Maybe they'll self-deport. Maybe if we make it hard enough, they won't go in the first place. So, you know, some of these attempts, like California trying to ban Chinese women, allegedly for them being prostitutes, for being lewd and debauched women, struck down by the Supreme Court, struck down by state courts. So that's what's going on. And you get a sense that each region of the country has their own conception of what is an undesirable immigrant. But you can see now at this point, before the Civil War, why the slave states would have never consented politically to federal immigration power or the ability to deport people. Wait, if the feds can deport people, are they going to deport all my enslaved people? Because that's my property. The Northeastern states are saying, whoa, 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 whoa. If the feds can let people in, am I going to get deluged in New York and Massachusetts by these poor people and these convicts from England? We don't want those people. All right, so the states would have never agreed to it. So the feds at this point have not yet consolidated control from the states because the states simply would not relinquish control over migration policy. Both the Northeastern states and the border states and all of those. Okay, so what are the feds doing? In the Civil War period, they dipped their big toe into the water. They're like, okay, let's try it. They passed the Anti-Coolie Act of 1862 in the middle of the Civil War. And every account of US immigration history omits this act, because the immigration historians said, this is about slavery. We study immigration. But if you take a look at that Anti-Coolie Act, it's directed against the Chinese coming to the southern states because the enslavers thought they would be a good replacement after the Emancipation Proclamation of the freedmen. So if you look at the justifications for the Anti-Coolie Act, it is infused with these justifications that come from anti-slavery, that no, we can't have another race of people that appear to be slaves, and they're not white and they're not Christian. So the whole effort to ban coolieism, which becomes synonymous with Asian migration, it turns out it racializes Chinese migration, and it makes this binary where European migration is free, Chinese migration is unfree. That's not a clean binary, because a lot of the Chinese arriving in the West are signing contracts, and they're doing so voluntarily. Okay, what else are the feds doing? Here is a example of, if you're looking at, I was looking for laws that encourage or restrict the freedom of movement and remain. And I'm not the first to argue this, but the Homestead Act is a federal law about it's federal land policy. Many historians have also made this argument that federal land policy was migration policy. They were channeling people into areas of the West to flood out and outnumber Native people. They were channeling people, white families, into the West to make it uncomfortable for Native communities, so they would move and they would sell their land. So the homestead policies of federal migration become, the Homestead Act in 1862, it says that not only are people, white families, eligible who are already in the United States, but you don't even have to be a citizen. If you declare an intent to naturalize, then you can get very cheap, heavily subsidized federal land. What else are they doing? 1864, the federal government passes a law to encourage migration, European migration, by allowing these short-term contracts for people to sign contracts to come to the US, because most people in Europe and in China can't afford to buy the boat ticket to just come. It's very expensive. So these contracts allowed people to, okay, your employer is going to garnish part of your wages to pay for you to come here. This is not new. This is indentured servitude. We've had it since the colonial period, but it's new because the federal government gets involved and they're trying to encourage it. But these contract labor situations, that is what many of the Chinese are doing. That's the same labor arrangement. But it's okay for European people, not so okay for Asian people. Asian people, oh no, that's slavery. That's coolieism. So there's this, this dual track stuff going on. Meanwhile, what happens to free Black people before the passage of the birthright citizenship clause? Because their citizenship status is unclear, they are in danger of the Americans' colonialization society, which was not, by the way, not a fringe group, because all these major Republicans also supported it. Free Black people were in danger of being repatriated to Africa and to parts of the Caribbean and to Latin America, because even Republicans who supported abolition of slavery, most of them could not see until I've got it where I said in the paper, until like 1860, 1870, they could not envision a multiracial democracy and society where free Black people could live peacefully and productively with white people. So their thought was, if we free Black people from slavery, we need to repatriate them to another country. How do you repatriate someone to a country they never visited and set foot in before? So for free Black people, it was very uncomfortable because it was never clear whether this colonization stuff, is it voluntary or not? And the federal government and state governments, they set aside money for it. So they wanted to make it happen. And it didn't happen because of the passage of the 14th Amendment, giving Black people citizenship, national citizenship, and because the Black community fought back and said, no, we're not doing this. We're from here. You will give us rights and we will stay. So finally, we have federalization. Finally, 100-something years of state level control of migration ends. Okay, why does it happen in 1882? Why then? Because the Civil War takes slavery politically off the table. So the slave states are no longer so crazy about defending their right to exclude international people or domestic people. They're like, okay, slavery is gone, okay, whatever. The Chinese arrive in large numbers, and the Supreme Court is striking down the state's ability to guard themselves against poor people, sick people, disabled people, and against California trying to guard themselves, allegedly guard themselves, against Chinese prostitutes. So once all these state level laws are struck down, the timing is significant. It's because slavery is gone, because the states have lost their ability constitutionally to control migration. And the calls come from the states out west and in on the Northeast, the states all band together and say, you know what? If Massachusetts, New York, and Connecticut cannot protect themselves from a deluge of poor people, then you the feds, you deal with it. We don't want to deal with it. And in the Western states, California, Oregon, Washington, the states said, hey, listen, man, if you're not going to allow us to ban the Chinese, then you do it. So in 1882, the immigration policy transitions to federal control. And that's where my book ends. That's where my talk will end. And someone asked me during Q&A, this is all very cute, all this history lesson, what does it matter for the contemporary period and for lawyers today, for people who care about this stuff today? Thank you.
Thank you, Professor Law. We'll turn it over to Professor Chen for some remarks.
Thank you. Very exciting talk, very exciting paper, important issues. As I read this paper, I thought of something that's not explicitly mentioned, at least in this chapter, and that is critical race theory. And I thought that while critical race theory is legal in California, I should take the opportunity to talk about this paper in that context. So I thought of the late, great Professor Derek Bell's interest convergence theory. And Professor Bell said that historically, whites tend to give rights to people of color when it benefits whites. That's when these things happen. For example, as the chapter notes, when the Supreme Court said that Chinese people born in the United States were beneficiaries of the Citizenship Clause, they mentioned that the opposite rule would deny citizenship to Europeans who have always been considered citizens when born in this country. So I thought about some of the good things that happened to people of color in the course of this story, and I wonder whether Professor Law thinks that they're part of the immigration story, part of the racial regulation story. One is federal slave trade suppression. And so this was a series of laws authorized by the Constitution that were designed to prevent the continuation of the Atlantic slave trade. I wonder if Professor Law would agree that they are part of the immigration story. In 1819, we have the first permanent deportation law. There was clearly, scholars argue, a humanitarian motivation for the suppression of the slave trade. Nobody thought that it was decent, even slave owners. But but it also shaped the demographics of the United States. It also reduced the number of people of African ancestry coming to the United States. So I'm wondering if Professor Law thinks that that is part of the immigration story, as well as obviously the slave story. Another issue is Reconstruction. There's a very interesting book by Professor Kermit Roosevelt, The Nation That Never Was, that says we can't look at the founding of the United States as the source of any legitimate notion of equality, because the equality that the founders had in mind was for a certain group of white European men. We should look at Reconstruction as the beginning of founding of equality in the modern sense. The Eric Foner calls Reconstruction a second founding, but was it in any way anti-racist in the modern sense? So we have the 15th Amendment that prohibits discrimination against people, citizens, on the basis of race in voting. That was, the word citizen was deliberately put in there to allow states to discriminate in voting on the basis of race against non-citizens. The Naturalization Act of 1870 extended the privilege of naturalization to persons of African nativity and descent. Charles Sumner said, let's just take the word white out and let any person naturalize without regard to race, and that was voted down multiple times. So would Professor Law agree that there's no majority in Congress for the idea that race is irrelevant, even for African Americans? Where is the white self-interest in all of this? The Three-Fifths Compromise drives this forward, maybe. That we have to do something with the 13th Amendment and the Emancipation Proclamation and the end of slavery in the United States. The Three-Fifths Compromise, which counts enslaved African-American persons in the South as 3/5 of a person for purposes of apportioning Congress and the Electoral College, that goes away, because there are no 3/5 of all, there are no all other persons to be discounted to 3/5. So is the consequence of the Civil War going to be to increase the power of the Southern states? The white Republicans in the North say no, but not because they particularly necessarily, all of them, a majority of them, care about African-American suffrage. They care about white Republican Northern suffrage, at least two. So is Reconstruction a resolution of the problem of the status of African Americans without necessarily being in any way a rejection of the idea that race is a legitimate consideration in public policy? And if so, to answer the question that you left with, which is, what difference does this make now? Well, the Supreme Court now has a new interest in originalism. What did the founders of the Constitution think about various constitutional issues? And it makes me wonder, is the modern version of immigration law, where with federal supremacy, consistent with originalism? I think I'll leave with the thought about the 1803 federal law that enforced the Negro Seamen's laws of the South. So in 1803, Congress passed a law that said, if anybody tries to import into the United States a person of color, enslaved or free, in violation of a law of the state, that's a federal crime. And the law also said that federal law enforcement officials are enjoined to carry out these state laws, help enforce these state laws. So in 1803, pretty close to the founding of the country, the Congress thought, our job is to help enforce state immigration regulations. That's what we're supposed to do, and what we're going to do. And so does that mean that someone should argue to the Supreme Court that the states can have their own immigration policy, and as Texas recently proposed to do, prohibit Chinese and others from owning land in that state? So a lot more to say. We'll stop there. Thanks.
Thank you so much. One person who's like real inspiration to me is a physicist. His name is Neil deGrasse Tyson. And he says that if you can learn one thing every day, then consider that to be a blessing. And I must say that I learned a great deal from reading the chapter that you shared with us. And the scholarship that you're engaged in, I think, is a project that is really valuable. This connection between slavery, the Civil War, and immigration policy. And it reminds me of other work that's been done on immigration study, which is historian Taylor Branch has also described about how the written, the connection between the treatment of African Americans and the battle for civil rights, and how connected that was to reformation of immigration law in the 1960s that removed the national origin quotas that were in existence back then, and it's changed the complexion of the country and the composition of immigration to the United States. But I'm going to pile on to what Jack has been presenting to you and all the other questions that you're going to get from others to try to bring us to some additional questions, which is, one of them would be the know-nothings. You write a lot about the know-nothing party and the anti-immigrants of the time back in that period. And I'd like to hope that there's a connection that's drawn to the present day Trump party, because I think that there are real parallels there that need to be, that could be addressed to kind of like bring this history into the present. And I think you alluded to that at the very end of your talk. Another question would be, what might America look like? This is more of a thought experiment. What might America, what would it look like now if our immigration policies, if we had not been, if we had not separated from Great Britain, and if we had been more controlled by Great Britain, and we didn't have the American Revolution, what would this, how would our laws be formulated in a different way? Would we look more like Canada? Would we look like New Zealand or some other place? And another thing that was interesting to me was some of the discussion about the accommodation of racism by Republicans of the time, including Lincoln and others, who were not really that particularly concerned about or focused on the rights of freed slaves, but were more interested in abolition. So how do you reconcile and work with and having abolitionists who are also racists, probably not as racist because of the time that they were living, but certainly they were clearly. How do you accommodate for that, and how should we be looking at that in the present day? And then the other one, which is that during the Trump presidency, there were some states, notably California, New York, and others, who were actually much more beneficial to immigrants. And in your discussions, you talk about this change of moving towards federal control. And so at sometimes we have a president or an executive branch, and maybe even a Congress that could potentially pass some really horrendous kinds of legislation. And how should we look at this in terms of states' rights? I think you bring up some of that, but you don't bring it into the present. But I'd like to hear more about that, maybe in the discussion. So I'm going to leave it there because I would like to leave it for, we don't have much time left for other people to be able to raise their questions, but I've really appreciated having this discussion. And I see it really more as a start of a discussion that might take us into what should this world look like going forward. So thank you.
Thank you to both of our discussants. I don't know about you. I really want to hear Professor Law's answers, but I know that there are more questions. So if it's all right, what I'll do is I'll put on the table one more question from the student seminar, and then maybe you can take a few minutes to respond to the pieces of the first cluster, and then we'll see if we have room for another round. I put together two questions from our student seminar. The question is, what is the impact of the free labor movement during that time period? In particular for Black citizens, but also what are the implications of that free labor movement for the racial hierarchy that's developing between the white European immigrant workers, the Chinese laborers, and then also those freed slaves?
Okay, thank you for those discussant questions and comments. Let me start in reverse order. The free labor movement for Black people, the Republican Party was concerned that Black people should be working for a wage and not be owned as property. And that's the middle, that's the, you know, there are abolitionists, there are radical Republicans, but the entire party is agreed on that point that free Black people should be able to work for a wage. But the problem with that idea, as I see it in this, when I was researching this chapter, it's very narrow to think of Black equality as just wage equality. What is the point of Black equality if you only have the right to work for a wage, but then you're discriminated in your, it's allowable to discriminate in your hiring if employers can discriminate against you and pay you less than a white person? And so the equality of Black people and any people, it has to be broader than just economic rights. It's very clear that when the Republican Party, I mean, they're still better than the Democratic Party, who thinks that Black people should have zero rights. But it's so narrow and cramped. And we're in a time period where, unless you're a radical Republican or if you're African American, the conception of rights, as Jack pointed out in his comments, is always in relation to, okay, how's it going to affect the white people? And a lot of abolitionists were pro-free labor, anti-slavery, because they thought, well, slavery poses an unfair economic competition to poor white people. They're concerned about poor white people. They're not less concerned about the well-being of enslaved Black people, but they're concerned about the economic ability of poor white people because of the economic competition, allegedly. So all of it is sort of relational. Richard's questions about, how does this connect? I can't get to all the questions, but Richard's question about how does this connect to the contemporary period and states' rights? I mean, that's exactly one of my points that I will end with in the conclusion of my book. So this is a slide. It is on the Department of Homeland Security website. It was on the website during the Trump administration. It was on the website during the Obama administration. It is still on that website today. This is the official governmental story of our US immigration policy. And it perpetuates several myths. One is that, before federal control, it was open borders, people could come and go, people could just, come here, pick themselves up by the bootstraps and, make a go at it. Yeah, just because there was no federal immigration policy didn't mean the borders were open. And this slide is also suggesting, there was no immigration policy until the feds took over in the late 19th century, and they only had to do that out of the national interest and concern for the country, because we were being swamped by immigrants. Also a lie. Because you start wondering, okay, whose interest is this? So when I read this slide, I thought, okay, if you're concerned about originalism, this is ahistorical and completely inaccurate. And I'm not going to argue, and I'm not arguing that we should devolve control over immigration to the states. But as Richard pointed out, because we have a federal system, okay, yes, some very terrible things are being done by the red states, Texas, Florida, flinging migrants all over the country for fun, and not trying to address the complex problem of why there is forced migration. But I don't want us to get into the habit of, yes, of course, all national federal policy is legitimate, and any state attempt to manage migrants is patently unconstitutional and illegitimate. That's not true. I don't accept that. And I would hope that all of us, whether you're pro or anti-immigrant, that you realize that the location of the line dividing national and subnational control over immigration, it's still being contested today. And the Constitution, it just says there's line. And so the states are testing the feds about where is that line. And it doesn't mean, we have just experienced from the last orange man, federalized, centralized migration policy does not mean pro-immigration policies at all. And that actually the states, the blue states, are doing some really interesting things on protecting undocumented people and legal migrants. So I want us to keep that in mind. Let me stop talking so we can have another round of questions.
Great, thank you. And actually your last response speaks to one of the another question that came out when we were talking in the seminar about the possibilities for states to engage in integrative measures, such as the New York is Home Act in your home state, which of course didn't pass, but was a really good effort, and places like California, of course. So I wanted to pause for more. Are there questions, live questions in the room before I turn to the online questions, the others that I've recorded?
This is something I was curious. Also, amazing lecture. I really liked it. But I always get curious because I'm in Common Law 1, so I'm now like actually reading the Constitution for once. But I'm like, I'm more surprised that. Oh, thank you. That why didn't the founding fathers simply explicitly put race in the Constitution or the 14th Amendment? Because they did it with the Chinese Exclusion Act, and I know the 1927 Johnson-Reed Act, they basically banned immigration anywhere outside Europe except Latin America. So I'm more surprised that they kind of shy away from it in the amendments, but kind of leave it to the states and some of these other laws to be more explicit on race, where with the 14th Amendment, they could have just said, there's no birthright citizenship, but everyone who is formerly enslaved is a citizen. Do you have any comment on that potentially?
No, that's a good question of why they didn't more directly address race in the Reconstruction amendments. They put, that you can't discriminate against someone based on citizenship and previous condition of servitude, because it was directly meant to address the status of Black people. You know why they put that word citizen in there? They didn't want the Chinese to be able to get citizenship. The Naturalization Act of 1790 is limited to free white persons. And in 1870, the Congress had the opportunity to take the word white out. And the Western states said, we cannot have Chinese naturalizing. Okay. The great fun of having Chinese people as migrants, I've seen this in the multiple people are saying it at this time. The great fun of having Chinese people as migrants, they can never become citizens. They can never vote. Isn't that fantastic? So they could have, but they number one, they meant to address Black citizenship. And number two, they really were not going to allow Chinese people to naturalize.
We have two online questions. I think they're a little bit beyond the scope of the paper, but maybe, but I'll post them in case they're
Okay.
in other parts of the book. One question comes from Robin Harper. She says that she's wondering if there are any restrictions on dual citizenship at the time. And then another question, unidentified, but also that came up in some of the reflection papers from the student seminar, is about the relationship between the groups we've identified and Native Americans at the time.
Okay. So the question about dual citizenship, I'm not aware of prohibitions against dual citizenship, but the bigger problem before the Reconstruction amendments is that there's the right to expatriate yourself. If you immigrated here and you become a citizen and you're a naturalized US citizen, we're talking about Lucy Salyer's book, Under the Starry Flag. There are a number of many Irish people that come here and they naturalize. And then they get involved in Irish politics at home. And they get into trouble with the Irish government, and the US government says, yeah, I have no responsibility for you. Well, what protection or allegiance is owed to naturalized citizens? So the right to expatriate, that, you know, the Irish people left Ireland, they became a US citizen, that's not clear. That's not made clear until after the Reconstruction amendments. But the much bigger issue is the lack of clarity is, do free Black people have citizenship, state citizenship or national citizenship? Because there are Black people who are free, who are not enslaved, applying for passports before the Civil War, being denied by the State Department, saying, you're not a citizen of the United States. Why do you need a passport? So that's the bigger problem. The lack of clarity on Black citizenship, and also the relation of the hierarchy. Okay, what's the relationship between national citizenship and state citizenship? If the state of Massachusetts and Connecticut and Virginia give you state citizenship, does that trump national citizenship? What sorts of rights are in each package? It's clear for white people, it's not clear for Black people. The question about Indigenous people in this chapter, so the annoying thing about bringing someone in like me who's writing a book, my answer is it's in the previous chapter. I do address it, and Indigenous people do play a huge role, because I see that the federal government in the 1830s, the federal government is still very hands off on state migration, but they are using the full power of the federal government to forcibly, violently deport. We're talking 80,000 people, 80,000 Indigenous people. That is not just the Cherokee and the Trail of Tears. That goes beyond the Cherokee. The federal government is financing it. They're hiring people to remove Native people at gunpoint. They're not providing enough money for food and medical supplies. So huge percentages of people die. And why is that happening? Because they're clearing the way for white families and for the expansion of slavery in the South and cotton growing. So I'm not sure. I'm trying to weave the story of Indigenous people into this, the whole story I'm telling, but they are central to it. And that's what I mean by the ability of each group's ability to freedom of movement and remain are all relational. And I've come to the point where toward the end of this book, where I do not think it's responsible to teach US immigration policy, history, and law without slavery and without Native history. I mean, whether I can execute it in this book is an entirely different question. I mean, I hope other people will do it too. I mean, I sound so brilliant, but actually, this is it's an antebellum migration history is a growing field in the history of in the discipline of history. So I'm building from the works of many historians, and there's a small but hardy group of us and we are very loud. So,
Thank you so much to Professor Law.
thank you.
Very much looking forward to reading all the chapters in the book when it's ready for publication. Quick reminder to our audience, our next speaker on February 2nd is David Fitzgerald from UC San Diego's Department of Sociology. He's also presenting new work on the ethnicization of refugee resettlement with Professor Masalo as the discussant. Please do RSVP online. I just wanted to quickly mention for the online people, we're going to try to change the settings so that if you're not from Hastings, you can still log in without a password. But if that doesn't happen, all the more, please do write to the Rice email and we can make sure that we share that information along with the links for you. There are different links for every lecture. Thank you all. We'll see you on February 2nd.
Yeah, it's like in class right now, and I usually get yeah, no, because I have this like where I'm at. Oh well. I like them a lot.